Well, good morning and welcome to all of you to Series 3, Episode 5 of 39 from 39. We are absolutely delighted to welcome so many of you. At last count, you are just shy of 200 this morning. And we're thrilled to have so many of you tuning in to hear the reflections of Richard Eaton and Angela Sydenham, with a few from me, Richard Wald, on village greens. Where have we got to and where are we going? Angela Sydenham will start off, and we are absolutely privileged to have two so very qualified speakers to address us this morning. Angela is the author of numerous books, including one on commons and village greens, and her presentation is entitled Maypole. Far we've got and a beautiful green patch of land when we are looking at towns and village greens. Richard is immensely qualified also to speak on this topic, having been involved personally in the TW Logistics case for the best part of a decade. His then fellow partner in Birketts conducted the inquiry, Nigel Farthing, but Richard, as solicitor, advocate and partner, conducted the High Court proceedings and really did most of the heavy lifting in those proceedings, because at that particular point, the registration authority adopted a neutral position and had relatively little involvement. I was delighted when Richard invited me, not on the basis of his great success on the High Court that he needed this, but when he invited me to join him in the Court of Appeal and then subsequently in the Supreme Court. And we've now had for about a month the judgment of the Supreme Court, which, like the judgment of the Court of Appeal, was favourable to our client. And it's really, Richard will be looking at the nitty-gritty of that decision, and then I'll come back afterwards to make a few remarks on where we're going really, and the post-registration position. We aim to address you all for about 39 minutes, that's the formula, and then open up to questions. We've had some questions already. We would encourage further questions in the Q&A section that you'll find at the bottom of your screens. And for those who want to watch this again or recommend it to others, you'll find it recorded on the 39 Essex website, along with many other webinar presentations on numerous topics that are available to you if of interest. So without further ado, I will now hand over to Angela, who will start with the topic of what no Maypole, and then we'll hand over to Richard. Thank you all.
Sorry, Angela, I'm just having a few problems now moving the slides along.
Here we go. Thank you. Because I'm like Gerard Ford, I can't chew gum and walk at the same time. So Richard has kindly agreed to move the slides on for me. Next slide, please. Here is the traditional village green. Although this photograph was taken on the Mad March day, you can see it's an attractive sight. It's what you might call a green green. Next slide, please. No, back one. Can we move it along so that I can read what the slide says? No. Well, anyway, here is a description by Carmarth LJ in what was known as the trap downs case. The traditional village green needs no introduction. Village green, the very words are evocative of great age and tranquility, of turf as rich in hue as it is trim in setting, untouched by time. The traditional green with memories of Maypole dancing and warm beer. Hoffman also gave a very lyrical description. He said, the traditional village green is a creation of the literature of sensibility in the late 18th century. The green at Oban in Goldsmith's The Deserted Village, 1770, is the best example, a place where toil remitting lent its turn to play, and all the village train, free from labor, led up, and all the village train from labor free, led up their sports beneath the spreading tree, while many a pastime circled in the shade, the young contending as the old surveyed, and many a gambol frolicked o'er the ground, as sleights of art and feats of strength went round, and still, as each repeated pleasure tired, succeeding sports, the mirthful band inspired. Next slide, please. Not too much cricket here, or dancing round the Maypole. This is what you might call not a green, but a concrete green. What sort of activities can take place here? Well, Hoffman said in a case called Sunningwell in 1999, said that there was no necessity for a communal activity, but informal sports such as dog walking, blackberry picking, playing with children were quite sufficient to merit the registration of a green. So what was done here at Mistley? Well, there's a wonderful view across the River Stour to the Suffolk coast. There's a lovely strip of mud where at low tide you can watch the birds. At high tide, there's swimming, crabbing, tying up of boats, and what else? Probably that's about it. But people walked and talked, enjoyed the view, watched the birds, and generally enjoyed having access to the water. Next slide, please. So how did we get from a lovely green to a concrete grey-green? The answer lies in section 22 of the Commons Registration Act, 1965. Unfortunately, I can't read it all because I can't move the slide along. Town or village green means a land which has been allotted. Could I remove myself and then?
And would it help if I read it out? I think others can read it. Town or village green means land which has been allotted by or under any act for the exercise or recreation of the inhabitants of any locality, or on which the inhabitants of any locality have a customary right to indulge in lawful sports and pastimes, or on which the inhabitants of any locality have indulged in such sports and pastimes as of right for not less than 20 years.
Thank you very much. As you see, I can't sort of see all the writing. This definition didn't divide the greens into A, B, and C, but subsequent case law has. So allotted greens are referred to as class A. Customary greens are referred to as class B. And these greens which are highlighted in blue are now known as Class C. And the result of this was that some 20 years later, there were many applications for town and village greens. Next slide, please. The Trap Grounds case was one such a case, 9 acres of land, 2/3 underwater, and the rest impenetrable, scrubby undergrowth, was registered as a village green. Next slide, please. What was the purpose? Well, Carnworth LJ, as he was then, expressed his view in the Court of Appeal. He said that there was no hint of a new village green coming into force after 20 years use. He said the purpose was to overcome the difficulty and expense of proving ancient customary rights, not to create new village greens after the initial registration period, and that looking at the Royal Commission report, which resulted in the Commons Registration Act, there was no hint of a modern Class C, nor in the parliamentary debates. But given subsequent case law and the fact that when the definition was revisited in the Countryside and Rights of Way Act 2000, there was no question that new village greens could not be created after 20 years. New slide, please. Moreover, in the Trap Downs case, Lord Hoffman gave 8 reasons why there should be no restriction on land which could be registered as a green. And he cited examples where the Commons Commissioners had registered rocks as a village green and land used for an annual Guy Fawkes bonfire party, and the Court of Appeal decision, admittedly on a customary green, where a car park was registered. Next slide, please. So there have been several modern cases on the site. Redcar, it was held that a golf course could be registered as a green. And in New Haven, though eventually for other reasons, a green wasn't registered, it was acknowledged that a beach could be registered as a green. Next slide, please. So are there any constraints on the registration of a village green? Well, of course, there must be user for 20 years, nec vi, nec clam, nec precario, without secrecy, force, permission. Have I got that right? Without force, secrecy, or permission. A well-advised landowner will actually lodge a statement under section 15A of the Commons Act 2006 to prevent to end the 20-year period. So before it has elapsed, if already 20 years has been acquired, then the statement will not be any good. But if it's still running, he or she can lodge a statement which will bring the 20-year period to an end before it's completed. Of course, the 20 years will then start again. So another statement will have to be brought to bring that period to end for the 20 years elapses. The second restraint is if the registration of a green would be incompatible with a statutory purpose for which the land is being held. It doesn't actually have to be used for the statutory purpose at the time when the registration is applied for, but it has to be so held. And we have these three cases: New Haven Port, where the statutory purpose was to run a commercial port; Lancashire, where the purpose was to provide land for educational purposes; and the Surrey case, where use of the green would be incompatible with use for hospital purposes. Next slide, please. Claims for the registration of village greens often arose where, in spite of opposition, planning permission was granted for development. And so to avoid the development, the locals would apply to register a village green. So in the Growth and Infrastructure Act, am I right? Yes, it says so. It must be right because I said that on my slide. They said that you could not register a green if there was a trigger event. And the trigger events, as you see, are mostly where there's been a publication of a planning permission, or there is development plans, draft or final development plans, or local or neighborhood plans identifying the land for development. The terminating events would then enable applications to be made for registration of a green again. And that, as you see on the slide, which I can't, the right will become exercisable after the application is withdrawn, declined, or where permission is granted for the project to start within a specified time, but that time has elapsed without the development taking place. Next slide, please. Oh, I've finished. Hooray!
You were right and have done phenomenally well, given that for some reason you weren't able to see your own slides. But let's pass over now to Richard, and then I'll chip in towards the end.
Richard, thank you very much, and thank you very much for your generous introduction at the beginning. I was certainly relieved to have Richard's input at the appellate stages, which was really helpful. As Richard said, it was nearly over a decade ago when the events that gave rise to the registration application started. This was the erection of the fence, which you saw in Angela's slide in 2008. And it's been a long road and perhaps an expensive one for the port owner. People might be interested to know that we were able to take part because we succeeded in getting a protective costs order for Mr. Ian Tucker, the original applicant. So our costs exposure was limited or capped at £3,000 in both the Court of Appeal and the Supreme Court, and slightly more generous cap in the High Court. And that's a really good example of cost capping in cases which fit quite well with the sort of corner house rules for protective costs orders, where there is a broader public benefit. So let me just give you some ideas, an orientation around the quayside. As Angela said, there's not much green in this. Now this is an interesting slide because it shows the competing coexisting users. In this case, the port traffic Now, it's fair to say this isn't necessarily an objective or typical representation of the intensity of port traffic, but it does show that it has some commercial use. You can also just see over by the blue VW on the right-hand side, two tracks. These are former railway lines. One of the less strong arguments put forward in the High Court was that the use of the village green wasn't lawful because we were trespassing on a railway. Clearly, there hasn't been a railway there for some time, so that argument won little favour. So let's just have a look at it from an aerial view. The village green is around sort of the middle of that picture. You can see there's a barge moored up against the side of the quay, and it's actually moving up from there along the side of the estuary. But what you can also see from this slide is how the village green, and Mistley is in fact a large village, not a small town. The village green links to the town and the high street. I think you can see that again on this slide, which is the registration slide. So you can see the high street of Mistley running parallel to the river, and the houses in between, and those houses sort of back onto the village green. So it really is perhaps unusual in that it combines this public access with it being a commercial port. Very different, for instance, to the commercial port, say at Felixstowe, where clearly it's one of the Europeans' biggest container ports, and security is very strict and barrier entry, where the public couldn't get access. So let's have a look. The leading judgment was given by Lord Sales and Lord Burrows, and you see, I'm giving you some extracts from the judgment here, that they noted their initial surprise that this qualified as a village green because it's an area of concrete, some 200 square metres, etc. And perhaps a little bit of surprise because the coexisting user case which paved the way for this kind of application, Lewis and Redcar, was a decade earlier. And what distinguished Lewis and Redcar was that the coexisting uses were both recreational. In Lewis and Redcar, the recreational use was walkers, and the owner's use was that of a golf course. And so the two weren't necessarily incompatible. And Lewis and Redcar gave rise to the doctrine of give and take. So coexisting user didn't necessarily mean that the inhabitants weren't demonstrating user as of right, as Angela said, without forced secrecy or permission. Even if when doing so, there was a degree of deference. The give and take might mean that the walkers would give way to the golfers when playing through the fairway. But that didn't necessarily mean that the walkers, so the Supreme Court found, that walkers were not exercising rights of sufficient quality to be user as of right. As long as they did enough to bring home to the landowner that rights were being asserted. So the interesting thing is that, as I mentioned from the slide, it's not a traditional green in the sense of sort of sports pastimes being organised games of cricket or rounders. It's more an area to congregate. It has the air, as the inspector said, of a village square, albeit in this case one with one side open to the estuary. And that's important because the user has to be walking. It may or may not be sufficient. It's not good enough for it to be a highway. And indeed, in this case, an application had been made to register as a highway some time ago, but the walking wasn't considered to be sufficiently directional from a point A to point B. And that's why it's more like a sports or pastime in the sense of a village green, because it's where people walk to congregate and to meet and chat, like a village square. And I think in the current pandemic lockdown, these spaces are perhaps more important than ever before, when one has to look for local recreation and limited social contact with social distancing. So what was the central question in this appeal? Well, it had been whittled down, but the central question really arose as an extension of the statutory incompatibility arguments, which had won favour with the Supreme Court in New Haven and Lancashire, which Angela's mentioned. And that's perhaps a little surprising because the port is privately owned. So there's nothing that would say there was no compulsory purchase, and there was no statutory power which was exercised in order to hold the land. But it was the criminal statutes which were said to frame the statutory incompatibility. And the way it was put was that the principle of coexisting user will allow the landowner limited rights, but usually to continue the enjoyment of the property they had before registration, after registration. And the way the appellant put this was that if the post-registration use continued, wouldn't that use become criminal under what are called the Victorian statutes, which were the statutes enacted to protect village greens, which had only an eye on the rights of the inhabitants, not of the landowner. So anything which disturbed or interfered with the village green enjoyment, the appellant said, would be a criminal offence. So when one looks at the regime for registration, and when one looks at the regime for the protection of the Victorian statutes, and indeed the health and safety legislation for protecting village greens, one might say that it wouldn't have been Parliament's intention, and so they ran the argument, that such land would qualify for registration as a town or village green. So let's have a quick look at those acts. As you can see, they reflect the language of their time from a Victorian era. But the critical things here are where they're public nuisance statutes, and they're designed to avoid public nuisance on the village green. So the Enclosure Act is not to do anything willfully or without lawful authority, to lead or drive cattle or lay manure, soil, ashes or rubbish or any other matter or thing. Now, there was some argument in the High Court and above as to that expression or other matter or thing and the application of the jus in generis principle. In our submission, it was a principle, the other matter or thing referred to categories of waste like manure, soil and ashes, not, as the appellant argued, to absolutely anything whatsoever. And again, that was a point which we were successful on in the case. And the same with the Enclosure Act, with the Commons Act, again, restriction, but based on the language at the time. And it's important to remember that obviously these Victorian statutes predated any notion of statutory registration by some 100 years. So the Court of Appeal's approach, Kim Lewison gave the leading judgment, and perhaps appropriately for somebody who's an expert on interpretation, that where there is an interpretation which doesn't render the use of the landowner illegal or unlawful in the criminal sense, then that's the interpretation that should be given to the Victorian statutes. And you'll recall from the language that there is scope for interpretation on those statutes. And they also drew attention to the case of Rimington, a House of Lords case in 2005, where something was held not to amount to public nuisance if it was warranted by law. So this opens up the principle that what is warranted by law is the granting or the retention of the right to do post-registration by the landowner that which it did before registration. And again, the Supreme Court said that the Victorian statutes are always speaking. And what they mean by this is that one does have to read into the Victorian statutes, or read into the Commons Registration Act, the era of the Victorian statutes, and update them and interpret them through the lens of the registration authority, which has since come to pass. And again, if there isn't a path available which doesn't interfere with the landowner's rights, then that should be taken. So the Supreme Court took this approach. So that perhaps the best way to understand it is that the starting point is not to look at the Victorian statutes, but to look at the principle of coexisting user and what it is that the landowner is able to do post-registration. And the principle of coexisting user says that the landlord is able to do broadly that which he did before. And in so doing, it would not be unlawful. So the threshold or the crossing point for which activity would become a public nuisance or unlawful would be when the landowner was going well beyond what they did before. Now, of course, this raises interesting questions about how to, about evidence, because the register of towns and village greens doesn't record the nature of activity. It simply says whether it's a green or not. And one of the concerns may be that in the midst of, with time, the passage of time, one may not recall the quality and extent of user that was carried on by the previous landowner. But nevertheless, the without lawful authority or warranted by law means that it's unlikely that the landowner's activity in post-registration period would be unlawful or criminal. And the question of the health and safety legislation, again, was perhaps a weaker point than the Victorian statutes, because of course the health and safety legislation is not triggered by registration. It's always been there. And so the argument ran that that in the 20 years leading up to registration, the landowner had to comply with health and safety legislation. So how on earth could health and safety legislation be a reason not to entitle registration as a town or village green. And interesting, there had been peaceful coexistence and a sense of give and take. There was no record of any health and safety problems, although interestingly, it was the health and safety executives' concern about the open quayside which gave rise to the fencing, which led to the registration application. And there remains a discussion about what type of fencing is appropriate. And what's clear from the judgment, if you look at paragraph 90 of the Supreme Court judgment, is the way in which the Supreme Court would expect this to happen now is that if there is a genuine health and safety concern, then the landowner should consult with the inhabitants and listen to their views about recreation. And in this case, the fencing really is an eyesore and really does interfere, in our view, with the proper enjoyment of the village green. One of the benefits of it is that it's perhaps that's not clear from the slides. It has fantastic views of the Stour estuary, and certainly it's used by many artists. Will sit there with their easels, or people will just come to appreciate the view. So, at paragraph 90, what they say is that you should consult with local inhabitants. The registration authority, as the upholder of the public interest, should also be consulted. And again, perhaps there's some a new nod towards the more active involvement of the registration authority post-registration. And it's possible to think of a compromise, and certainly a position I put to Barling in the High Court, which he thought was appropriate, was that the fence didn't have to be 8-foot Harris fencing. It could be of a nature which is perhaps common in other areas, where you might have a lower fence that allows for clear safety issues to be addressed, but also doesn't impede the attractive view of the estuary or the enjoyment of the green as a place of recreation. So the question of statutory incompatibility, in a way, hasn't been resolved fully, because the feared criminality of the landlord's behaviour was said to was the landlord worrying about nothing, and actually he wouldn't be criminalised. But the Supreme Court left open the question of if the inevitable consequence of registration was criminalisation, and that remains a question to be answered. Although if one thinks about it, if the right is to be able to carry on after registration as you did before as a landowner, then it's hard to envisage any situations in which that behaviour would be rendered criminal, and therefore the criminality would be a bar to registration. So finally, just a word on where does that leave recreation rights. And there was quite a lot of, in the numerous cases that have been in the House of Lords or the Supreme Court, a lot of discussion about the symmetry or alleged asymmetry of rights pre and post registration. I talked quite a bit about the position of the landowner, but it's also helpful in this judgment that it gives some guidance on what sort of rights are the inhabitants entitled to enjoy post registration. There are two competing views, I suppose. One is that they are allowed to just carry on with the same type of rights that they had before. So it would just be walking, crabbing, and maybe painting on the quayside. But what if they wanted to play a game of rounders or have a picnic or a game of cricket? And then the other view is, there's an asymmetry of rights, that once it's registered, it's a one-size-fits-all, and any recreation would be permissible. And what the court said here is that actually it's not that there isn't a constraint on the nature of the activities which one is entitled to enjoy post-registration, but one does have to have regard to the impact on the landowner. So in a way, it doesn't matter what you do, but just don't do it in a way which has a greater burden on the village green. And one might think of my game of rounders, that may be okay if it's not at a time when the port is in action and transiting lorries are going past. But if it was during a transit period, because the village green is between the dock and the warehouse area of the linear quayside, clear it would be, I think it will probably be going too far to be able to insist on continuing a game of rounders and while the lorries had to wait. And what happened in this case is that for 20 years there has been easy coexistence. And actually there was quite important evidence at the non-statutory inquiry given under oath, where the inhabitants said that even though there was regular port traffic, there was never a time when they would not go to the village green because the lorries were running. They could easily let them go past. The speed limit for the lorries was about 10, not more than 10 miles an hour, and it would take only 10 or 15 seconds for a lorry to go across the village green, and thereafter they had the freedom to enjoy the green as before and walk around it. So I hope that's been a helpful introduction and to some of the issues. And I'll now hand over to Richard for some discussion.
Well, thank you very much, Richard and Angela. I'll invite Angela to become visible again. And before we move into Q&A, I'll just make a few remarks. I think that the combination of Angela's and Richard's presentations tells you really where we've got to. But the question remains, where are we going? Now, the last of Richard's slides tells us in very clear terms that the fact of registration as a TVG, a town and village green, is no longer to be regarded necessarily as a binary one. It's not one size fits all. So where does that leave local inhabitants, and where does that leave the owner of the land? And indeed, where does that leave registration authorities? If it's not one of those traditional cases where there isn't coexisting, fair to say coexistent user. But Mistley is obviously an example of where there was coexistent user, like in the red car case. And it begs the question, what can the landowner now do and what can local inhabitants now do? Well, we're guided in that regard by the principle of give and take. The land is registered, so local inhabitants are entitled to use it for lawful pastimes. And the owner can carry on using it as he or she did, provided there isn't intensification or change of use, such as to interfere with the acquired rights of local inhabitants. Now, in this case, there is a very comprehensive account of what went on over the 20 years qualifying period. We have that in the form of the inspector's report. Alan Aylesbury, the inspector appointed to deal with the inquiry, produced a very comprehensive account of that history of give and take. And then after that, Mr. Justice Barling's judgment gives a further account of the nature and extent of the use of the land by local inhabitants and by the owner. But what about cases where there isn't such a comprehensive and public record? I think the answer is that it does place more of a burden on the registration authority to in some way chronicle how the land has been used over the 25 years, necessary years of user, and not just record that it has been registered. There isn't a formal mechanism to include such a description, such as one finds in the planning context in certificates of lawfulness. But there is, I think, a useful analogy that we can find in the contaminated land context, because under Part 2A, land can be registered contaminated if it meets the tests for contamination. And there is no mechanism for deregistering it. But what happens as a matter of practice is that when a landowner is required to remediate land, a notice of remediation can be added to the register, and it can be recorded that the relevant authority, the local authority, was satisfied with the remediation process. So I think that gives us an interesting model. I don't think there's anything to prevent a registration authority where it's needed from adding some form of description to guide local inhabitants and to guide owners as to what is the extent of permissible user. And that record could be used, if necessary, in the context of a criminal proceeding brought under the Victorian statutes or for whatever other purpose. Now, finally, fencing, and we've had a couple of questions come in on fencing. Richard took us to the penultimate paragraph of the judgment, in which really gives expression to a concern or a possible solution to a concern that Lord Sales offered. The Health and Safety Executive should consult wherever it is sensible to do so, local inhabitants, registration authority. And the judgment even suggests that where that consultation is disregarded, judicial review might be contemplated. So I think the consequence of that sort of a process would be to achieve something that's quite different from the fencing that is currently in place. I say it's currently in place. The landowner has not yet moved to remove it, but it's hoped that that will happen before long. So those are my remarks on where are we going. I think where we're going is an enhanced role for the registration authority, but also I think, and I know that there are lots of delegates that have joined us today from local authorities. There is, I think, to be expected an enhanced role for you if you are the registration authority. But there's also, for those of you who are tuning in from solicitors' firms, a lesson to be learned from Birketts, because I don't think it would have been necessarily obvious to many of us who practice in this field that there was a registrable village green at this location. And I think the key for others that are involved in this area or become involved because a client raises a question is to be a little more open-minded about what sorts of areas, drawing upon Angela's slides, might now be open to registration. Now, I'll finally pick up on a question that we've had about the position in Wales. I personally have not had to deal with a town and village green in Wales, but I know that Section 15 applies there. The judgment in Mistley, the TW Logistics judgment also applies there. And I also know that there is a useful guidance note that is issued by the Welsh Government on Section 15 of the Commons Act of 2006. So I will just invite our other speakers to comment on their experience either in Wales before I pose another question that I think is aimed for Angela. But do either of you, our other speakers, have experienced the position in Wales?
No.
Okay.
Not me. Only I think one of the more extraordinary registrations was of some rocks in Wales, wasn't it, on the where boats were moored. I'm not sure, but
yes.
I can't offer you anything else.
Well, there's a question that's come in that I think is for Angela. Angela, we're asked whether Class C registration breaches any aspect of the European Convention on Human Rights, and I wonder if you could pick up that question before I move on to one of our other questions that have come in.
The Convention on Human Rights provides that there shouldn't be any interference with possessions. But we have a case, I think the answer is no, because there is no deprivation of a private possession at all here. So the answer is not against Article 1, Protocol 1 of the Human Rights.
Yes, and I think that's Lord Hoffman essentially says that, doesn't he, in his judgment?
Yes, he does.
So well, let's move on to a pair of other questions, which I'm going to initially direct at Richard. We've had one question relating, I think that's come from the Parish Council, about the scope, if any, there is for construction on the surface of a village green. And then if I can add to that, we've just had a question, what rights would travellers have if they pitched up on a village green? So perhaps, Richard, you can offer your views on both of those questions, which are somehow connected.
Yeah, certainly. Thank you, Richard. Yeah, so far as the Parish Council is concerned, it's not an absolute prohibition, but this does take us back to the Victorian statutes, and it's Section 29 of the Commons Act, which says any erection or disturbance or interference is unlawful, other than for a view to the better enjoyment of such town or village green, because it would be a nuisance. So it is possible to do it if you could say, one could envisage perhaps a pavilion or some sort of building which would be compatible with recreational rights. But it's harder to envisage that in, say, a coexisting user case, where a structure on the village green would impede the rights of the landowner to carry on their activities as before. And then to take the traveller's question, well, I think I would start by saying, if one looks at the language of the Commons Act, it's a benefit, not a broader public benefit, but of rights for local inhabitants. So my view is, unless the travellers happen to come from the the local vicinity, they would be trespassing and could be, the landowner would have all the remedies available to evict trespassers under sort of persons unknown proceedings. I don't know if anyone else shares that view, but that's certainly my view.
I certainly agree with that. Angela, if you have anything to add to that, or shall I pick up another question that we've had in?
Well, except that it used to be exclusive use by the local inhabitants, and then it was predominant. So it doesn't stop other people coming on. But travellers might be a different issue.
I'm just having a look at, we've had a couple more in just now. If a village green clubhouse, perhaps this comes back to your answer, Richard, is erected for the benefit of football and cricket, which have traditionally been played there, this has been consulted upon and planning permission granted, then presumably this would be consistent with the Victorian statutes. Could you get away with erecting a clubhouse, Richard, for that purpose?
Yeah, well, that's a really good example, actually. I mean, obviously, it's a question of fact and degree, so it depends perhaps how big the village green is and how much, how big the structure is. But generally speaking, this would fall squarely within the exception to the prohibition under Section 29, because it is for the better enjoyment of the town or village green. And obviously, the category of what is a lawful sports and pastimes is very broad, and would certainly encompass football and other like sports. So from a village green or Victorian statute position, I don't think there would appear to be any offence to that of that nature.
Now, a very interesting question just in now. Could a former telephone kiosk situated on the forecourt of a private property and now being used as a book exchange for the village be capable of being registered as a TVG? So I suppose the question there is whether book exchange is a lawful pastime. It's certainly not one that I've ever seen before. Richard and then Angela, any views on that one?
Well, thanks, Richard. Yeah, I'm not sure. I mean, one could, I mean, it is pastimes, and one might say reading could arguably be a pastime. And it's for the better enjoyment of that pastime. So as I put on the spot, I'd say I think that falls within the definition, but I wouldn't like anyone to go off and rely on that. So I put a health warning on that and say I would want to give it some further thought, but on the face of it, I don't see why not.
It's not an open air activity though, is it?
Well, does it have to be an open air activity?
Well, all the examples we've had so far haven't been in buildings, have they?
Well, I know that the TW Logistics was I think the 10th time in 20 years that the Supreme Court or the House of Lords have considered the functioning of the regime relating to the registration of town and village greens. Perhaps this is the opportunity for the next occasion, because certainly it's not something that I don't think any of us have seen before. But why not? And I think there's one last question I think we've got time for. Let me just check the Q&A. They're coming in. Yes, I've got well, there's a question, what appeal mechanisms are available to defeat or rescind the registration of land as a town or village green? Well, funnily enough, the hearing that Richard did solo as solicitor advocate in front of Mr. Justice Barling was exactly that. I think it's in section 22, Richard, which is an application, or have I got the section wrong?
Yeah, no, that's right. It was an application for rectification under Section 14 of the 1965 Commons Registration Act, and that's effectively the opportunity for an aggrieved party to have a judge review the registration, and it's also an opportunity, really. The case of Betterment tells us this: the court aren't constrained in a sort of appellate capacity. They actually look at it anew or de novo. So in this case, actually, the appellant brought in lots of additional evidence. He tried to ramp up the extent of the commercial use by bringing an expert on logistics and haulage to say there was little time, opportunity, or space for recreation, because they looked at weighbridge tickets and the volume of ship traffic to show how much loading and unloading would have happened. But if anyone wants to read the judgment, you'll see the judge wasn't terribly impressed by that activity, but also because it didn't displace the opportunity for the recreation by the inhabitants. As I mentioned, they put a lot of weight on the fact that inhabitants were never deterred from seeking recreation. So yes, there is an appeal as such, but as I say, it's an opportunity just to look at whether the registration continues to be appropriate, and that's under section 14, and that's where the Essex County Council took the view that they didn't wish to get involved in any analysis of the new evidence, but were there to uphold the inspector's decision. Interestingly, for local authorities, Barling said that actually they didn't need to be quite so cautious, and that if a registration was appealed under section 14, they could in fact take any point, as indeed we gratefully acknowledge they did in the Court of Appeal and the Supreme Court.
Great, thank you. Well, I think we're coming up to the hour, and it's probably time to draw the threads together. Thank you to our two speakers for really informative presentations. And I just suggest in conclusion that this is an area of the law that's not going away. Whilst Angela pointed to a number of statutory mechanisms to restrict registration that appear in the Growth and Infrastructure Acts, and there have been others, at the same time, the effect of the TW Logistics judgment is, I think, to open up the scope of possible areas that might be registered, particularly where co-existent user is in play, and where perhaps people hadn't even contemplated the possibility of a town or village green being registered in that particular space. So I wouldn't be surprised if the extraordinary rate of consideration of TVG registration in the highest court of the land continues in the years to come. But for now, let me thank all of those who've tuned in once again for doing so. Thank you.